Hello and welcome everyone. Today we'll be discussing a case regarding Section 2 of the Charter of Rights and Freedoms. Section 2 of the Charter protects our fundamental freedoms, giving us freedom of conscience, religion, thought, belief, expression, peaceful assembly, and freedom of association. These freedoms are included in our Charter to make sure Canadians can freely create, share, and talk about their ideas with others without fear of being punished for it. Although these freedoms are extremely important in our society, the government can sometimes place limitations on them. For example, a person's freedom of expression may be restricted by laws against hate speech or child pornography in order to protect citizens and communities from harm. This is the matter I'm going to be discussing today. Section 2B of the Charter states that all Canadians have the freedom of thought, belief, opinion, and expression, including freedom of the press and other means of communication. Over time, the courts have broadly interpreted what this entitles, so the Supreme Court has come up with 3-question test for analyzing this section. The first question they ask is, does the activity in question have expressive content, thereby bringing it within Section 2B protection? The second question they ask is, does the method or location of this expression remove that protection? Methods like physical or threats of violence fall outside of this section of the Charter. Furthermore, the location of expression is important because the expression in question occurs in or on a location of private property that is not covered in this section. The third and final question that the Supreme Court asks when assessing cases is that, if the expression is protected by Section 2B, does the government action in question infringe that protection, either in purpose or effect? Essentially, this means that if the government's goal is to limit what someone says, control what they can see, or stop someone from expressing their ideas, that action goes against Section 2B. That said, this third prompt implies that even if the government's goal doesn't directly go against Section 2B, a person can still argue that the effect of the government's actions violated their freedom of expression. These questions were the ones utilized by the courts in 2000 in the case of Little Sisters Book and Art Emporium v. Canada. The Little Sisters Book and Art Emporium is run by individual appellants, the director, and main shareholders, making it a privately owned corporation. What I found very interesting about this corporation in particular is that this emporium sells a variety of materials aimed at the gay and lesbian community, including books featuring gay and lesbian literature, travel information, general interest magazines, academic research on homosexuality, HIV/AIDS, safe-sex information, and gay and lesbian erotica. I found this particular case interesting because it is a very unique line of business in the 1990s to 2000s era. Since its opening in 1983, the corporation has imported 80 to 90% of its erotica from the USA. The legal issues we're discussing today are the issues the establishment began to experience when their inventory arrived at Canadian customs. I chose to discuss this case today because I found it shocking that something as ordinary as a book can be as controversial at the border as illegal substances. But it turns out, sure enough, under Canadian law and Customs Tariff Code 9956A, it's illegal to import books, art, or other materials that are considered obscene under the Criminal Code. When it arrives at the border, customs inspectors decide how to classify them based on Section 58 of the Customs Act. To do this, they compare the materials to a guidebook called the Memorandum D911, which gives examples of what Canadian Customs considers obscene. If something is found to be obscene, it can be banned from entering the country. However, after going through the internal review steps with Canadian Customs, the importer, like Little Sisters, can choose to take the case to court. First, they can appeal to a superior court of the province where the materials were seized. If they're not satisfied with that decision, they can appeal again on a legal issue to the Federal Court of Canada. Then, with the court's permission, they can appeal to the Supreme Court of Canada for breach of their charter rights. This is the same process that Little Sisters underwent after a lengthy trial that the trial judge found that customs officials had repeatedly delayed, seized, destroyed, damaged, and/or wrongly labeled the bookstore's imported materials on multiple occasions. It was ruled that these errors occurred because the store was being systematically targeted. The judge agreed that the customs law violated Section 2B of the Canadian Charter of Rights and Freedoms, but ruled that this violation was justified under Section 1 of the Charter. Section 1 protects our rights and freedoms, but also allows for reasonable limits as laid out in our laws to maintain free and democratic society. In the end, the trial judge decided not to strike down the customs law under Section 52(1) of the Constitution Act, as this would have meant ruling the law itself invalid or unconstitutional. Instead, the judge used Section 24(1) of the Charter to issue a declaration. He said that although the law itself wasn't unconstitutional, the way it was sometimes interpreted and enforced by customs officials violated Little Sisters Section 15(1)'s equality rights and Section 2B's fundamental freedoms. Their freedom of expression was breached when they experienced censorship at the border that blocked them from receiving expressive content, as well as when the customs officers subjected them to unfair and biased decisions. The Little Sisters Book and Art Emporium brought the case to a court of appeal, but their attempt to get a stronger immunity was denied, and the trial judge's decision was upheld. The Little Sisters bookstore then pled their case to the Supreme Court of Canada, where the decision was split. The majority declared that the appeal should be allowed in part. It was found that importers have the right to receive expressive material unless the state can justify a ban, and that while customs law can prohibit obscene material at the border, the law must be applied fairly and constitutionally. The discrimination against LGBTQ+ bookstore was found to be administrative, not built into the law itself, but still a charter violation. With that, it was said the customs officers acted unfairly and caused real harm to the bookstore and its customers. All in all, the bookstore was unfairly targeted and their charter rights were violated by the customs officers. That said, there are a lot of lessons to be learned here from the Little Sisters Book and Art Emporium v. Canada case, namely for the future business leaders of tomorrow. This case shows businesses all over Canada how government actions can impact fundamental rights such as freedom of expression. Business leaders should understand how to defend their rights, especially if they serve marginalized or minority communities, like Little Sisters does. Moreover, Little Sisters was targeted because it serves the LGBTQ+ community. Their resilience and push for not only the profit of their business, but for equal treatment under the law is a great lesson for business leaders of tomorrow to learn. Being an inclusive leader isn't just about the right thing to do, it can actually make a difference. Little Sisters Book and Art Emporium has highlighted that businesses have power to stand up against unfair systems and help create change for the better in Canada.